Welcome to the second in our series of talks with Goldsmith Chambers. I'm Fiona Lyon and I'm a partner at Anthony Gold. And I'm joined by Sarah Pinder, who is the Joint Head of Public Law and Immigration at Goldsmith Chambers. So I'm going to start the talk by looking at, in brief and in overview, the law on adoption. So the relevant legislation here is the Adoption and Children Act 2002, and this incorporates the Hague Convention, which we're going to look at in a bit more detail later. This legislation updated the existing law and brought it in line with the Children Act 1989. And the aim was to ensure that parental consent and the best interests of the child were addressed early. It also introduced the concept that the child's welfare is paramount. There was also a new adoption welfare checklist introduced, and this included looking at the long-term implications of adoption. It's also possible now to dispense with parental consent to a placement if the child's welfare dictates. And you can imagine a situation where a child is being neglected, but the birth parent does not want to agree to that adoption, so that can now be overridden. Next slide, please. So who can apply to adopt? I've included this because there's quite a lot of myths around who can adopt a child and what sort of criteria is involved. So single applicants can apply, married couples, civil partners, and individuals in enduring family relationships. So that would be cohabitees or unmarried couples, and also parents who already have children. So some other practical points are that if you are going through IVF treatment, there is an expectation that you would have a 6-month break between that treatment and your initial meeting with an adoption agency. And this is because it is obviously a very different process to adopting a child to having a child where there is a genetic link. So in terms of your what you can offer the child, there is no expectation that you'll be a homeowner, but obviously you need to provide suitable accommodation for the child. There's no minimum income threshold either, but you would also need to show that you have that financial stability. So as you might imagine, there are a lot of people who desire babies when they're thinking about adoption, but it's probably good to note that agencies are wanting to hear from people who are interested in toddlers, over 4s and siblings. Also people who are open to children with disabilities, children born of parents with mental health and/or addiction issues. And they also want to hear from Black or ethnic minority heritage or dual heritage parties who want to adopt a child within the same heritage, but also people who have the skills to adopt transracially. Next slide, please. So all people who wish to adopt are going to have to be approved. So the first stage is to register with an adoption agency, and they will then do criminal checks and look at your background. So obviously, if you've been convicted of any offences against a child, you're not going to be considered. You also need to have references and a medical report. And it's just a note here that smokers will not be given priority when it comes to adopting a child, due to the environment that they might be able to provide. So the would-be adopters will be invited to attend a preparation group with other adopters where they will learn parenting skills and they can ask questions of experienced adopters. If all goes well after that, you would move on to stage 2, which is the training and assessment part. So with that, you would work with a social worker to prepare an assessment plan. You'd be given training by an agencies on supporting a child, and ultimately a prospective adopter's report would be prepared. During this time, you're going to have home visits from a social worker so they can understand the child's new world. And that's going to be looking at everything from religion, ethnicity, finances, your family setup, your health, and what support network you've got. So again, if that all goes well, you would move on to the panel approval. So the report will be presented to the panel. That panel would be made up of adoption professionals, independents, and adoptive parents. The prospective parents would attend that meeting and they would be assessed for suitability during that meeting. So once that happens, the panel will or will not make a decision and a recommendation to the adoption agency, and that will then ultimately result in the agency making a decision, and they have a decision maker who makes that final decision. Next slide, please. So once you've been approved for adoption, how do you go about matching with your child? So at that point, the social worker will begin the search once you're approved, and they have links to local authorities. The child's needs are going to be prioritised above the adoptive parents at that point. And during this time, further training can be obtained by the prospective parents in readiness for the arrival of the child. Once the match is found, a social worker's report will be presented to a matching panel, and that panel will decide if the child's needs will be met by the prospective adopters. And again, a recommendation will be made back to the agency decision maker, and the very important final decision will be made at that point. Next slide, please. So once that decision has been made and you've been matched, how do you become a family? So you are supported by a social worker during this process, and they will help you get to know your child. There'll also be the moving in process, and the child will need to be with you for 10 weeks before you can make an application for an adoption order. Now, when you make an application for the adoption order, the birth parents are going to be automatically parties to that process, unless they've given notice that they don't want to be informed. But even if they do that, they're still going to be told of the final hearing. And that is because if an order is made, all ties will be cut to that child. So once the adoption order has been granted, this will confer parenthood and parental responsibility on the adoptive parents, and it will permanently cut ties to the birth parents and any existing orders. And that's important when you think about things like guardianship orders or child arrangements orders that could be in place. Please note that if you are a step parent thinking about adopting a child, it might be more appropriate to think about an application for parental responsibility because the adoptive order will cut ties with the absent birth parent. So it might be taking too much of a step to do that, and parental responsibility might be a better process. So just want to mention here that adoption leave is actually offered by most employers to facilitate this process, and you should look at those policies with your employer if you're interested in pursuing this. Next slide, please. So I'm just going to move on to talk about intercountry adoption. And as you can imagine, this can be quite a complex process, and it even differs within the UK. So just to note here that Scotland and Northern Ireland do not have stages 1 and 2 that I previously outlined in the approval process, whereas Wales does have the 2-stage process. So really important here to note that offences can be committed if children are brought into the UK without the proper procedures. And I think Sarah will probably address that a bit later on. So the UK has ratified the Hague Convention on Protection of Children and Cooperation in respect of intercountry adoption 1993. And what this does is provides an intercountry framework for adoption aimed at preventing trafficking and protecting children. If you were a signatory country, you must have a central authority, and that is the point of contact for adoption agencies, but also they hold all the information in relation to the adoption. Next slide, please. So just some international considerations, very much in overview here. So if you are looking to adopt in a different country, and this can be for various reasons, you may have a family relative in another country, you may have links to another country, and it may not be that it falls into a convention country. So you need to think about that. So there are convention adoptions, and those are countries where they are signatory to the Hague Convention. So there's just some examples there, and there obviously is a lot longer list. But much of Europe are on that list. Mexico, Peru, Korea, China, they're quite popular destinations. So some of the non-signatory countries to bear in mind are countries like Bolivia, Kenya, Colombia, Cuba, El Salvador, Ghana. There are a lot more on the list than the countries that I've listed there, but that's just to give an idea. So the absolutely key point to note is here that if you're able to do a convention adoption, that means that you can obtain the adoption abroad, and it means that you basically don't have to adopt the child when you return to the UK. You may have to get certification from the relevant central authority, but providing all of this is validly obtained, then it may be that you don't have to apply for an adoption when you arrive with the child back in the UK. Really important to note that if you don't go to a convention country, that you will have to do the adoption back in the UK, and it might be transferred or dealt with by the High Court, and that is due to concerns about human trafficking, etc. Next slide, please. It's really important to also note that there are restricted countries, and to really avoid these countries when looking at adoption. So a few of those countries are Cambodia, Guatemala, Nepal, Haiti, Ethiopia, Nigeria. The reasons why these are known as restricted countries are because they operate procedures that are contrary to the Hague Convention. So there has been evidence of falsification of documents, facilitators working on a commercial basis, safeguarding concerns, a lack of competent authority or legal framework to deal with the adoption, and obviously child trafficking and corruption. What you should note is that if you did want to adopt from one of these countries, and let's say you've got a family member there, or there's some sort of serious situation that you need, where you need to adopt the child, you can apply for an exception to be made. So there is an exception to all of these rules, but again, you would need good legal advice before you took that step. Next slide, please. So adopting a child from abroad, just going to cover a few things that you might want to think about. As I've already said, this can be a complicated procedure, and it's going to involve scrutiny from the UK authority and from the child's country of origin. All adopters, whether home or abroad, are going to have to be assessed and approved. So again, the first step is to contact the local authority social services or voluntary adoptive agencies that have been approved for intercountry adoption. In the UK, adoptive parents cannot be discriminated against on the usual grounds, but there's no international consensus on same-sex or transgender parents, so please do look into that if you were looking to adopt abroad. Again, as is probably obvious from the previous slide, you really need to check whether the child is coming from a signatory country to the Hague Convention, and this will also affect their nationality. And Sarah's going to talk to you a bit about that later on. So if you are adopting locally, as in abroad, you need to also double check that you are actually adopting on the grounds of a full adoption, i.e. you're cutting all ties with the birth parents. And this is not what is known as a simple adoption, where some ties remain. If you have obtained a simple adoption, it will be recognised in the UK and it can be converted, but you do need to check on what type of adoption that you are doing locally. And again, lots of advice should be obtained locally and in the UK before you do that. Next slide, please. So what's the eligibility for an international adoption? So you need to be over 21, you need to have no convictions against a child, you need to be habitually resident or domiciled in the UK, and some countries require 1 year's habitual residence. And you also need to go through the suitability process to be approved by an agency, as I previously outlined. So the procedure after that is that once the parent is approved as eligible, an application needs to be sent to the Department for Education, and the fee is going to be means tested and will vary. And the other place it could be sent to is the relevant UK central authority to check if you meet the eligibility criteria. Once you are deemed eligible, a certificate of eligibility to adopt is issued and sent to the relevant overseas authority. You do need to check whether that needs to be translated or notarized as well. So once you match with a child abroad, you need to visit the child and then confirm that you have done so and that you want to proceed to the UK agency. You need to check whether you need to go through the adoption court process in the country you're adopting from in order to leave with the child. And you also need to arrange entry clearance for the child to enter the UK. And again, Sarah's just about to tell you about that as well. And I should just point out that the child must be eligible to adopt as well. So consideration needs to be given to local adoption, whether it is safe to adopt that child and whether it is in their best interests. Next slide, please. So just to round off, I just want to look at the court process for the adoption order. So the application needs to be made on the form A59. That's for a convention order, and you also need to submit the UK birth certificate or the foreign birth certificate. You may want to add some additional evidence, such as foreign court documents, death certificate of the birth parents if relevant, marriage certificate to show your relationship with your fellow adoptive parent, any immigration documents as well. So once that is done, a first directions hearing will be listed. And at that hearing, the judge is going to look at whether the criteria has been met to make an adoption order. He's also going to look at whether further evidence is needed, timetabling will be dealt with, and any disclosure information that needs to be given to the birth parents. They will then either list a final hearing or the further directions hearing. At that point, you can expect a CAFCAS will be involved and also a report from the local authority or adoption agency to be ordered. Once we get to the final hearing, that is going to be the point at which the adoption order is made. And I just want to point out again that the court cannot make a convention adoptive order unless the child has lived with you for 10 weeks immediately prior to the application and the Home Office has confirmed the child is authorised to enter the country and reside permanently. And on that note, I'm going to hand over to Sarah and she's going to talk to you about the immigration issues around adoption.
Thank you, Fiona, and thank you again for having me. As you've just heard from Fiona in terms of the last slide, it just shows again how you need to have joined up thinking and parallel sort of legal advice and specialist advice when you are looking at inter-country adoptions. So I can't stress that enough. In terms of my part of the talk, it will obviously focus on inter-country adoptions because of the impact on nationality and immigration statuses and positions. And so on this slide here, on the first slide, I've just set out the Home Office guidance, which can be useful if you need to turn to that in a bit more detail to help you navigate this. But again, I can't stress enough how it's important to get the legal advice to help you through this process. From a nationality perspective, you have two sets of guidance, and I've detailed those there. One specifically looking at adoption, and then one which is sort of pan-nationality guidance with regards to children, and that is registration as British citizen on children. And it's there's a specific section from page 19 of that guidance looking at children adopted by British citizens. And then from an immigration perspective, you have a separate piece of guidance which is very useful: adopted children and children coming to the UK for adoption. So just a quick word about those two sets of guidance. What I would like to kind of reiterate really in this talk is that you may have different routes that you need to look at, different considerations depending on the type of adoption, and we'll come to that in a minute, but also depending on whether the child upon an adoption or going through the adoption can effectively target British nationality immediately, or whether you are looking at immigration solutions in terms of having your child join you following the adoption or as part of the adoption process in the UK. So I just wanted to highlight those two frameworks there, and you have the guidance. In terms of the legal framework, just at the bottom of this slide, there's the British Nationality Act 1981, which governs the nationality provisions, and then really in terms of the immigration considerations, applications for visas and so forth, it's the immigration rules. And so in the next slide, if I could have that, please. I've just set out really the immigration considerations to start first. So effectively, adoption-based applications for entry clearance, which is the term effectively for a visa, are very similar to other children applications. So if you're here in the UK and you have a child of yours, a biological child, and you want that child to join you from your home country in the UK, the adoption-based applications are very similar to those. So it's similar financial requirements, similar focus on documentation in terms of your status as a parent in the UK. So I've just set that out in brief terms in the second bullet point. But what really differentiates adoption-based applications to, if I may say, biological children applications is really determined by the adoption itself and what sort of adoption we're dealing with. So you need to be looking at the type of adoption that you may have already effected if you're seeking advice once the adoption has been completed. Or obviously, as Fiona has stressed already, if you're looking at this in advance of undertaking this process, you can really try again and choose as best as possible, as best as practicable, the type of adoption that may work for you and that may be the smoothest to go for. So look at what type of adoption you're dealing with. Is it recognised in UK law, etc., as that will then determine what options are available for you if you need to go through nationality or immigration solutions. And so on the next slide, I've just highlighted there really from an immigration perspective the different type of adoption. So there is some repetition from what Fiona has taken us through already. And again, the tiers of adoption in terms of how easy they might be. going down the scale is the same. So you start with adoptions under the Hague Convention, which you've already heard of through Fiona's talk and been taken through in terms of process. So that is the smoothest process to go through from an immigration and nationality perspective as well. And we'll look at that in a bit more detail after. Then the second level, so to speak, is overseas adoptions, which are recognized in UK law. So again, already touched on by Fiona, but I've just detailed there the statutory instruments that effectively give you the lists of countries. And if the adoption is contracted or is completed, finalized in that country, then the fact that the country is present on those lists will mean it's recognized in UK law. But it doesn't necessarily stop there in terms of simplicity, because you do have several lists, and those were amended as we went along as well. So you do have there detailed in that second bullet point, adoptions that have been finalized before the 3rd of January 2014. So again, you'll need to know the date and have that documented in the final order or equivalent if it's a foreign court, obviously. And you look at the adoption designated of overseas adoptions order of 1973 and the order of 1993 that is detailed there. And then you have adoptions that are finalized after the 3rd of January 2014. And again, you have two separate statutory orders depending on where you're dealing with it, where you're effectively based. So as highlighted by Fiona in terms of different arrangements, even within the UK, here you can see that with the first being applicable to England and Wales and Northern Ireland, but then Scotland having its own set of recognition of overseas adoptions regulations. Okay, so relatively straightforward if the country is on those lists, but again, it takes time to go through that and to make sure that that hasn't changed. And again, going down the scale, overseas adoptions which are not recognised in UK law. So again, highlighted by Fiona in terms of restricted countries, but also countries that effectively don't feature anywhere, whether they're Hague Conventions or in the lists that I've just highlighted in terms of designations of overseas countries. And effectively from an immigration perspective and a nationality perspective, as far as the UK is concerned, adoptions that are finalised in such countries that are not listed anywhere are very difficult to get recognised, and then are very difficult to have affected in terms of nationality and immigration rights. So if you are making an entry clearance, a visa application to a post overseas for your adopted child, if they are adopted in such a country where the adoption is not recognised, it is very likely that that application would be refused. And again, it goes without saying that there would be no nationality entitlement to British nationality, for example, flowing from that adoption, even if both parents are British, because that adoption is not recognised. So you need to be very, very careful if you have a situation where the adoption is contracted there, is finalized there, and then take it from there in terms of seeking specialist advice. It's not impossible, and I've just highlighted there the case of W versus the Secretary of State for the Home Department of 2017. Already you'll see, again, it's a High Court case, as highlighted by Fiona. Often these cases will be transferred to the High Court because of the complexities and the international element. But you know, there's no comfort in my view to be drawn by the fact that there is a reported case or some reported cases that show success in an adoption that wasn't otherwise recognised in UK law, because it takes time, litigation, the stress, the cost of that, and the uncertainty at the end of the day. So it's really not something to sort of go to because there's been success previously. If it can be avoided or worked through in a different way, then that is always best. And that leads me to the last bullet point on this slide, the way of working, so to speak, an overseas adoption that hasn't been recognised is to have that classed as an inverted commas de facto adoption. Now, I want to stress straight away, and you just have that in brackets at the last bullet point, that a de facto adoption is purely an immigration law concept. There is no parallel concept in family law. It may not be a concept that's used in other countries either. So it's purely a concept that has arisen through the development of immigration law in the UK. It's defined in paragraph 309 capital A of the immigration rules. And effectively, it's there to recognize that there may be situations where an adoption has taken place and some time has elapsed and the arrangement has been lived, so to speak. And so it is right in all of the circumstances of that particular case that will again get scrutinized quite heavily for the adoption to then be recognized as far as immigration law is concerned. So the three requirements that I've summarized there for you are that the adoptive parents need to have been living together, so the two adoptive parents together abroad for at least 18 months. So again, it's to recognize a situation where perhaps the parents have been living in another country and not necessarily planning to return to the UK, have effected this adoption according to that country's procedure and laws, and some time has passed, and so it can then be again scrutinized but recognized in immigration law. But there are other requirements. So, and the adoptive parents need to have been living together with the child for a period of 12 months, and that is all preceding the application for the visa. And again, the adoptive parents have cared for the child for the full 18-month period. And as part of that, there will be an analysis as to whether there is something to be concerned with. Is this trying to circumvent the immigration rules? Otherwise, has the child again sort of been detached from their birth parents? So have those ties been effectively severed, or is there a concern here that otherwise means that effectively the adoptive parents have not cared for that child? So it can be a useful, depending on the case, a useful route to go under if you meet those criteria, and perhaps in order to have the overseas adoption that's not recognized, but it will depend on the case and obviously the ability of the parents to have been abroad for that period of time and so on. If I could have the next slide, please. So I'm just returning back up the list, just going through a few things, but some of these have already been flagged by Fiona, so I need not spend too much time on it. But effectively, we have the panacea, so to speak, in terms of the Hague Convention adoptions. As you heard from Fiona in detail, such adoptions require the assessment from the UK Adoption Agency. But what I'm highlighting in the next bullet points is effectively the different ways that you can have the child return with you to the UK, and where that process might fall in the adoption process, and then what you may obviously need to then do from a nationality or an immigration perspective. So adoptions can be completed either in the state of origin, so the Hague Convention country where the adoption is started, and it can be completed there, would usually be completed in the UK if the state of origin seeks a 6 to 12 months fostering period first. So you don't have to take that period in the Hague Convention country abroad. It can be done here. If the adoption is to be finalized in the UK, then you aren't able to go to, you aren't able to turn to nationality options yet, because the adoption hasn't been finalized, and the nationality entitlements of the child would flow from the adoption order. So instead, you can turn to paragraph 316 capital D of the immigration rules, and that is an application that effectively gives 2 years of leave to enter, leave to remain to the child, in order to permit the adoption process to be completed. And then once the child is here, you go through that period of completion in terms of the adoption process in the UK, which will should take place usually within that 2-year period. And then you then would have, if all goes smoothly, the adoption order. Upon the adoption order, then that child would become British. So the immigration process in effect stops there. But the child would only become British if at least one of the parents are British themselves. So there are, again, quite strict criteria, quite nitty-gritty criteria that you need to look at from a nationality perspective as well. And so experts, again, are good to resort to at that stage as well. If neither parents are British, but they have permanent residence, for example, they have residence rights in the UK, then you can make an application for the child to obviously be granted leave in line with that. So you just turn back to the immigration route instead. And really the process is the same, more or less, in terms of the adoption process being finalised in the state of origin. So if that's the case, and instead of the UK, then if the final adoption is taken place in the Hague Convention country, as Fiona highlighted, that would finalise the adoption. And so you can turn to the child becoming a British automatically flowing from that adoption, as long as one of the parents is British, and the parents are habitually resident in the UK, as I've detailed there. And you have Section 1.5 of the British Nationality Act 1981, which is where that stems from. But again, if neither parent is British, then you just turn to a different paragraph in the immigration rules, which is paragraph 310, specifically for adopted children. So that is when the adoption is finalised. And so then the child is granted indefinite leave to enter the UK as your child, effectively as if your child was your biological child, but it's just a different section dealing specifically with adopted children. In terms of designated adoption, so if you recall that list of countries in terms of overseas adoptions that are designated in those lists, depending on whether they're pre-2014 or post-2014, effectively you're dealing with the same. So you don't have an entitlement to British nationality flowing from a Hague Convention, but you look at either paragraph 310 or 314 because the adoption will have been finalised. The difference in the two paragraphs is if the parents have settled status or not. So if they're permanently resident in the UK, then the child can get permanent residence straight away under 310. But if they only have limited leave, for example, they might be here in a working capacity and they have an employer sponsoring them, then they can also apply for the child to be granted that limited leave under paragraph 314. If I could have the next slide, please. And just closing down, again, the scale, the sort of hierarchy of adoptions. And I've touched on this third category already in terms of the adoptions that are not recognised in UK law. As I mentioned, it's very difficult and effectively you are likely to be refused, but you can go through some solutions to try and sort of smooth things over, so to speak. So you can, another option that I didn't touch on earlier is you can apply and effectively go through the process again. So if you have undergone the adoption process, but it's not recognised in UK law, you can contact the a UK adoption agency and undergo a suitability assessment, which is conducted by that agency with a view to bringing the child to the UK for the purposes of adoption. But it does mean effectively going through that process from the UK all the way over, and so obviously can be quite time consuming and come with a certain level of uncertainty depending on the case. And again, that takes us back to the paragraph 316A of the immigration rules, which is the route that we looked at if the Hague Convention adoption is not finalised in the Hague Convention country, but is finalised here in the UK. So you can make an entry clearance application for the child to be brought to the UK with a view to undergoing that adoption process. But you need to have all your boxes ticked before you can go through that, as Fiona outlined in terms of the certificate of eligibility and that certification and so forth from the UK adoption agency and the recommendations and the decisions that come with that. And there have been cases, just aside from that, in terms of the non-recognised adoptions, where the High Court has actually recognised on a case-by-case basis the adoption as far as the UK or the law of England and Wales is concerned. But the cases that have succeeded, as far as I could tell, are cases where the parents have been able to show that they're not domiciled in the UK. So we enter a whole arena again of complex law and case law concerning domicile, which is a different concept to habitually resident. So again, I can't stress enough that you may not want to rely on that and sort of have that in the bank, so to speak, to get round an overseas adoption that's not recognised. If you have to, then obviously there are precedents there and specialist help can help you, but whether it's successful at the end of the day is still very uncertain. And de facto adoptions, we come back to paragraph 310 and 314, as I've highlighted. So really, I can't stress enough that just beware when you undertake this process, or if you have undergone the adoption process and it's not one that's recognized, or that it's a designated country, seek specialist advice for your own reassurance, for your own guidance, and help to navigate you through this. But also don't underestimate how complex this is at the Home Office end as well. Inter-country adoptions involve procedures from different countries, a lot of documentary evidence, as Fiona has highlighted. And the caseworkers at the Home Office will also get it wrong. They will think that you need a certificate of eligibility when you don't. They will think that you need, the UK agency's decision here in the UK, but if it's an overseas designated country, you don't. So they can get it wrong. So it's important to have that process to also guide the Home Office or the British Post Overseas, so that you can maximize your chances of any application being successful. And just to close, I'm highlighting the case of TY, which is another immigration case, this time in the upper tribunal of the Immigration and Asylum Chamber. And effectively, it concerned an overseas adoption in Jamaica. And we had the unfortunate situation in this case where Jamaica was on the designated list pre-2014, but then following the changes was no longer on that list of designated countries. In the mix of all of that, the adopter, who was here in the UK, I think a British citizen as well, had done everything that she should have done. So had the UK agency on board, had been deemed suitable by them, had all the recommendations and the decisions on that front. But because of this shift in terms of Jamaica being bumped off the list, so to speak, there was confusion at the entry clearance post stage, and so the application was refused wrongly, and it took an appeal to the first tier tribunal, which I think was dismissed, and then an onward appeal to the upper tribunal to be resolved. And so again, that is stressful, a lot of funds being spent, which can be avoided if you obtain specialist legal advice early on. And specifically with this case, it was highlighted that the legal representatives involved in the first tier on both ends, the Home Office and the adopter's end, had not really done their respective clients' service, and that was specifically highlighted by the upper tribunal with regret and with some criticism. So again, you can't take that enough in terms of guidance, and so it is important to do what you can for you as prospective adopters in order to ensure a smooth process. And so on that note, I think I'm coming to an end, and you have our contact details there. Over to you, Fiona.
Thanks very much, Sarah. As Sarah said, very important to get advice, and that was a really important cautionary tale you just highlighted there. So you've got our contact details there. Please do get in touch if you would like some advice, and thank you for listening.
Thank you, Fiona.